On behalf of the Mecklenburg County Bar, thank you for selecting this recorded seminar for your CLE credits. The Bar depends on and appreciates your support. While we always love to see you in person at the Bar and Foundation Center, we know that this replay can be a real convenience to you by saving you some travel time and expense. For information on how to get your CLE credits with an MCB replay or online course, head to our website at www.mecbarcle.org. We'd also love to hear from you on new ideas you may have for future CLE programs. Thanks again for supporting the Bar, and now enjoy this program.
Hey everyone, Peter Bolac. I'm with the State Bar. I'm the Assistant Executive Director. I'm also the Director of the CLE program. So you're going to hear about the CLE rules from the horse's mouth today. I'm going to do a little quick update on the State Bar, do some talk about the new CLE rules. As Lisa said, feel free to put something in the chat. We'll try to answer your questions as we're on the topic. And if I don't get to something, then we'll talk about it at the end. And obviously, if you have individual questions related to your individual situation, always feel free to call or email us here at the bar. All of our emails at the bar are just the first letter of our first name and our full last name. So my email is pbolac@ncbar.gov. Deborah Holland, who's the director of CLE program, is dholland@ncbar.gov. So please feel free to reach out to us. I probably won't take a full hour, so but I'll hang around at the end to answer any questions and talk if you guys have any questions about CLE or anything else related to the State Bar that we can talk about. So just quickly, hopefully everyone knows, the State Bar is not the Bar Association, and we're the public agency that's created to regulate the profession for the protection of the public. That includes creating and enforcing the rules of professional conduct and reviewing those to change them as things warrant as times change. 2023 was a busy year. In addition to approving these new CLE rules that we're going to talk about, we've had another year of an increase of lawyers, 32,000 plus, 6,000 plus of those are in Mecklenburg, 6,000 plus of those are in Wake County. 5,000 ethics inquiries. Grievance numbers have gone way up again. They dipped during COVID, and we see a rise in grievances being filed. Seems like we're on track for even higher in 2024. Also deal with authorized practice investigations and deal with the attorney-client assistance program. That is something that if you get a call from ACAP, please cooperate or participate, because what they're trying to do is try to help resolve whatever situation might be happening between you and a client before it hits the discipline process. So ACAP is your friend. Trust me, you want to make sure that you're participating if they're reaching out, because they're just trying to help prevent something worse from happening. 2023 had a lot of programming at the bar as well. We did a random audit study that I'll talk about a little bit. We've worked on some deferral programs and succession planning. As it relates to succession planning, you can now go into your portal and designate someone as a potential trustee if you become disabled, disbarred, disappeared, or otherwise unable to continue your practice. You can name somebody that that you've talked to and said, if I can't come in the office ever again, I need you to come and help wind down my practice. And so optional, not required for you to do that, but it's something you can do now in the member portal. We've also been working on legal deserts and working on unbundled legal services. There's a potential rule change coming for the rules of court that will allow lawyers to provide that limited representation and unbundled legal services, help you get out of the case easier if you want to provide that limited service, and with the confidence that you won't be stuck in whatever case that you're helping out in. In addition to the CLE rules changes, there was legislative changes, I'll give you a little highlight of those here in a second. So the first thing we looked at, and I'm just quickly getting through these, is a random audit program. And this is one of those ones that really helped. This change is going to really help out and is create more fairness for the smaller judicial districts, which is certainly not you guys, but what we did when we studied to see who's getting audited and what's the ratio of audits per population, and we found that lawyers in the larger districts had a much less chance of ever getting selected for random audit because our selection process was based off of district bars. For instance, Mecklenburg has 23% of the lawyers, but only had 4% of the audits. So the committee recommended changes, which we made, which is instead of doing random audit selection by district bars, we're just doing random audit selection based off of a list of all the lawyers in the state and then scheduling those throughout the year. That's going to result in more audits in Wake County and Mecklenburg County, but we think this is a more fair process to where every lawyer has the same chance of getting selected for random audit. Legislatively, there was a lot of changes last year, and I'm sure you're aware of many of them. We got a cap, an increase to the dues cap for what the state bar can charge, but that's just the maximum allowable amount. It doesn't actually raise our dues, and we're not planning on raising dues until that's necessary. We don't intend there to be a dues increase next year, but we did get a $25 increase to do that in the future if necessary. There was a cap of mandatory district bar dues at $90, and which I'm sure you all are aware of in Mecklenburg. There were new appointments to the Disciplinary Hearing Commission that will be made by the legislature and the Chief Justice. They eliminated the state bar's appointments to the Judicial Standards Commission. And there was this establishment of a state bar grievance review committee, which met in between sessions to review the state bar's grievance process and recommend changes. Those changes came in a report, which has been turned into a bill, which was filed and amended and has now passed through the Senate that makes some changes to the state bar's grievance process. There's 4 or 5 areas that it's changing. One is the ability to get the materials of your grievance investigation prior to the grievance committee meeting and considering your matter, the ability to address the grievance committee when they're considering a grievance, for the respondent to actually get to address the committee. Rules regarding standing, like who can file a grievance. You have to have some sort of cognizable relationship to the lawyer to be able to file a grievance. Vexatious complainants, those people who are just constantly filing grievances against everyone without any merit, the ability kind of to create a gatekeeper rule against them. They've instructed us to draft rules related to expungement of low-level discipline, maybe admonitions or reprimands after a certain period of time, potentially getting those expunged from your record. So there's a lot of stuff in that bill. It's passed through the Senate. It's now headed over to the House. And once that, if that passes, and once that passes, we'll certainly update everybody on those changes that are coming that way. All right, so I know everyone's really here for the CLE rules changes, and so I'm going to go over them in pretty good detail here. But if you have questions or if you want to, if there's something that I didn't spend a lot of time on, please feel free to interrupt and ask any kind of questions that you have. Just as a reminder, your requirements for 2023 did not change. So you had to do 12 hours. There was an annual report that had to be filed by the end of February 2024. Failure to do that got you that $75 late fee. But that was the last annual report. One of the big changes in the rules is eliminating the annual report requirement. So if our records say that you've done your hours and you're compliant, there's no need for you to log in and hit a button or risk forgetting to do that and getting a fee just for failing to hit a button. So we've eliminated that annual report requirement, which was kind of a relic from the pre-computer time. There was the 2024 CLE attendance fee that you probably saw in the annual report process. That's part of the new rules, is instead of and I'll talk about this, but instead of that per hour fee, we charged a flat $25 fee that was paid in 2024. And those hours that you earned in 2023, we're going to still be able to carry those over into 2024 as you had in the past. So you're not going to lose those carryover hours. And this is a good chance to say that the CLE board's directed us, and we want to act in a way that, when we're making a decision, we're making it in the best possible light for the lawyers. We're trying to show as much grace and patience and flexibility as possible, with the hope that we can get at least some of that back in return over this bumpy year. Trying to get all these rules in place and programming for all of the new rules is difficult. Trying to have two sets of rules working at the exact same time is proving difficult. I think we're a week or two away from all of that showing up correctly in your portal. And but it's, if everyone can just kind of have a little patience and grace this year, that would be much appreciated. So that's 2023. But beginning in March of 2024, we had some significant rule changes. As I said, one of the big ones was eliminating the $3.50 per hour attendance fee. That was, often paid by sponsors, but I'm sure most of you on the Zoom here today have received an invoice at some point from the state bar for $11.50 or $17 or something for some course in which the sponsor didn't pay your attendance fee. And that wasn't very efficient. And it ended up making the, state bar having to play bill collector, which was not a good use of anybody's time. And so the change is, instead of that $3.50 per hour, which added up to $42 when it was 12 hours, that, while was often paid by sponsors, but was essentially the lawyer's responsibility, we reduced that to a flat $25 annual attendance fee that's paid each year by those lawyers who are not exempt from taking CLE. Someone asked about slides. Yeah, I'll make sure to share these slides with Lisa, and I think they're going to put this video also on the website. So the second big change is moving to a 2-year reporting period. So instead of having 1 year to do 12 hours, lawyers will have 2 years to do 24 hours. You can do that in any way you want to do. So you can do 20 hours in the first year, 4 in the second. You can do them all up front. If you have a busy time, you can wait, maybe do them in the second year. But we wanted to increase that flexibility for lawyers to be able to take CLE when it was more convenient for them. 4 hours of ethics, 1 technology, 1 professional well-being, which is the new name for mental health substance abuse hour. And you have 2 years to take them, except for 2024. And I'll get into the details. There's a 1-year exception for half of the bar that will be on a 1-year 12-hour requirement. And that's in order to create this staggered, so half of the bar is coming due every year. As I mentioned, we eliminated that annual report requirement. And we kept carryover hours. When we initially proposed these rules, you might remember in the journal, the initial set of proposed rules proposed eliminating carryover hours. We thought, well, you've got 2 years, 24, we'll just reset every 2 years, no carryover. And of all the comments we received and all the different things we were changing, by far the #1 comment we received was don't take away my carryover hours. So we thought, okay, well, we can bring some carryover over. So let's do 4 hours and propose that. So no, that's not going to be enough. Okay, 8. No, we want our full 12 carryover hours. And that's ultimately how we ended up. You still can earn 12 hours per reporting period to carry over to the next. The important change here with this is they're only going to carry over as part of your total hours requirement. So you have 24 hours that you have to take. If you have 12 carryover hours and 5 of those were ethics hours, they're not going to count towards your ethics requirement. They're only going to be part of your 12 hours that goes to your total requirement. The board felt strongly that lawyers need to take those specialty credits, ethics, technology, PWB, each reporting period. And it makes some sense if you think about it, because if you took you know, 4 substance abuse hours, the PWB hours in the first year of your 2-year reporting period, and we're able to carry those over, then you wouldn't have to, you wouldn't take anything your second year because you'd already done it. You wouldn't have to take anything the third year, the first year of your second reporting period, because you'd carried those over, or the next year, or the year after, and you'd really only have to take something in the, fifth, sixth year. You could go 5 or 6 years without having taken some of those specialty credits. So they want those to be taken each reporting period, but you can carry over up to 12 hours as part of your total hours requirement. Except for 2023, we're going to let, if you've earned extra ethics or extra substance abuse technology, we're going to carry those over as the specialty items, just as a good faith measure from the old rules to the new. Another big change is the elimination of the grace period. I don't know, most lawyers probably don't even know there really is a grace period, but officially in the old rules, the CLE year ended December 31st, but you got a 2-month grace period through the end of February. Well, that created a problem, overcomplication, because in January and February, lawyers could be taking courses to satisfy 2 different years. So instead, we're going to have a 12-month CLE year that begins March 1st and ends at the end of February. February is the month we're all used to being CLE month, so we didn't want to change that. We also thought going to a calendar year would mean a lot of lawyers are trying to get their CLE done in December, in which there's a lot of other stuff going on. And honestly, everyone needs to take vacation, including the CLE department. So we wanted to be able to still be on, available to help at the end of the CLE year. So we're sticking with February. March 1 through the end of February is a 12-month CLE year, beginning this year. One of the trade-offs for all this increased flexibility for lawyers is kind of sped up enforcement of failure to do, of non-compliance with CLE. We did eliminate that annual report late fee because we've eliminated the annual report, but lawyers failing to complete their hours by the end of February will have a late compliance fee. And then after, I think 45 days or something, you'll have that non-compliance suspension, show cause suspension order. So the old rules, we would send out the, a notice to show cause, and then 60 days later, you'd get a suspension order, and you had 30 days to comply before you were suspended. Sometimes it could last through the end of the year before you were ever suspended for non-compliance. The new rules combine that notice to show cause and the suspension order that essentially says if you don't either show cause or complete your hours within 45 days, you're suspended. So we think that this is a fair trade-off and kind of streamline that enforcement process. If you are exempt from CLE, I'm doubtful you're probably on this Zoom if you're exempt from CLE, but all the different kinds of exemptions are still there. And if you're exempt, you don't pay that annual CLE attendance fee, and you will be claiming those exemptions during your membership dues renewal process. That's when you'll also be paying that annual attendance fee. So lawyers will only have to log in to deal with state bar stuff once a year, theoretically. If you become exempt during the year and later in the year, we're going to have a way for you to log into your portal and claim that exemption at any time. Exemptions are good for 1 year, and they kind of reset your reporting period each year that you're exempt. You'll start over a new 2-year reporting period. One of the trade-offs for getting rid of that $3.50 attendance fee is we're going to have course application fees for sponsors. So most of them are $50, regardless of the length of program. It's just a $50 fee. All of this is going to be able to be done online, hopefully in the next week or two. We're in the last stages of launching the sponsor portal to where sponsors can apply for a course, pay the fee, upload attendance, do all of that stuff in a portal. We think that this is, a really good change. We're going to get rid of all of the paper checks that you have to be mailing into the bar and all that kind of stuff. If you're offering free courses, there's not going to be a sponsor fee. So we want to encourage good free programming. So there's no $50 fee for a course that you're offering for anyone to take. So there's a lot, we're going to continue to provide information. So this infographic is from last year, but we're working on a full communications plan to get information out in all the various ways. We'll be doing more YouTube live streams and videos, pamphlets, probably do a mailer, do some e-blasts, stuff in the journal. Just try to get this word out and hope that you'll spread the word too to everyone who's not on this call. But ultimately, there's going to be people come February who don't know that these rules are changed, and our goal is at least to be able to say, well, that's because you weren't looking, because we've got that stuff out. Some other changes, and I'll get into what's going to happen in this particular 2024 here in a second. On-demand courses can be approved for 3 years. Then they need to be recertified just to make sure the content is still relevant and the laws haven't changed. We did change some of the wording in the mental health substance abuse definition. It's now professional well-being, but generally the same. Just wanted to modernize the language usage there. If you're a board certified specialist, this does not change any of your requirements to maintain your certification. That's never been officially tied to the actual CLE rules. So whatever hours you have to do in your field to maintain your certification, that has not changed with these rules. Our course search is going to be updated to let you search by cost, find free and affordable courses, have some more detailed information in the course search on the CLE site. On-demand programs need to be submitted. The attendance must be submitted by sponsors. So if you're taking an out-of-state on-demand program, you can't submit that yourself. The sponsors need to submit that. It's kind of a way to make sure that the out-of-state kind of large on-demand providers are not circumventing the rules and having lawyers submit things for credit. No changes to the P&A kind of requirements, other than if you are a new admittee, the professionalism for new admittees program needs to be completed within the lawyer's first reporting period. So, if they start out, if they're new in July this year, they'll have, a little over a year and a half to take that P&A. They'll have to do get it done by February of 2026. Here's a look at the fee schedule. There's no intent with any of this to increase revenue. We want to make things more efficient for both lawyers and the CLE program, but we're not trying to make more money. And so we've had to do an estimate and a guess, because we used to be able to know pretty clearly what our income, revenue was going to be, because it was $3.50 times 12 times the number of lawyers. But now, if it's based off of, half of it's based off of a program application fee, we can't be entirely certain how many of those will be sent in each year. So this may have to be adjusted, and maybe adjusted up, maybe adjusted down over the next few years as we kind of figure out what the costs are going to be and what we're bringing in each year. But there's no attempt at all to increase revenue for the CLE program. All right, 2024. Lawyers admitted in an odd year. So if you're admitted in 2015, 1997, 2017, you have a one-time, 1-year, 12-hour requirement like before, just for 2024. 12 hours, 2 ethics, 1 professional well-being, 1 technology. You'll still have your carryover hours from last year. And your first 2-year reporting period will begin March 1st, 2025. As I said, this is a way to have half the bar coming due each year, so we don't have a whole year, always have a whole year where really no lawyers are taking CLE, and really increases the efficiency for us here at the bar to be able to administer only kind of half of the bar each year, When the CLE program started in the late 80s, there was only about 15,000 lawyers, and now there's 32,000 lawyers. So, and the size of the CLE department really hasn't changed much. So, this is a great way to future-proof that as well. So we're not continuing to have to hire more and more people to help the CLE program. If you're admitted in an even year, 98, 2012, 2024, you go right, you're right in your 2-year, 24-hour requirement. So that started March 1st. Your 24 hours, 4 ethics hours, 1 PWB, 1 technology. That is due by the end of February of 2026. So you have that full 2-year reporting period. We chose even to go right into the 2-year requirement so that the lawyers who are admitted this year don't have a change happen to them 1 year into practice. So they're coming right in to a 2-year requirement. And that way, all the new lawyers admitted going forward will go right into that 2-year requirement. So the odd lawyers were the odd ones out to have that 1 year, 12-hour requirement. But after that, everyone will be in this 2-year requirement. We had talked about and even proposed, I think, initially having it be 3 years and 36 hours. We thought, well, that lawyers, that would be great. We'll divide the bar into thirds and do it that way. And that was the second most comments we received, other than carryover, was if you make it 3 years, 36 hours, that means I'm going to have to do 36 hours of CLE in the last month of February, in the February of my last year. And we tried to say, well, you don't have to. That's a choice you're making. But that was a comment we've received a lot, was that it's going to be really hard to do 36 hours in the last few weeks of February. So we settled on 2 years, 24 hours. We've done some YouTube live streams. We're going to do some more. These slides will have a PDF that has rule changes in it and some info, and I'll make sure to share these slides. And we're going to do some more YouTube lives, both for sponsors and for lawyers over the course of this year, so everyone understands what's going on. I will again ask for your patience. If you logged into your portal right now, you will not see what your 2024 requirements are. We've started to be able to post some 2024 attendance, so some of that will show up. But the requirements are still in the final stages of programming. Hopefully the next week or two, that stuff will be up and the sponsor portal will be live. So just if you're not in a crisis, you're not in deficit from last year, and you have some time, just take a break. Especially if you have in the 2-year period, you got a little bit of time to take a breather, but continue to take your CLE that's being offered and available, but just know that the portal is still a work in progress, and hopefully, I would say by the end of June, we should have all of that stuff available for you to be able to see and see those requirements and be able to track it better. But right now, it's still under construction, just because we had to wait until the end of February to be able to make some changes because the old rules were still in effect. So programming on that's been a little tricky, but it's working out, and we think we should be in a good place real soon. And then after we get through 2024, which is going to be a bumpy year, we think all of this is going to really smooth out, and everyone will appreciate these changes because it increases flexibility, efficiency, fairness, I think, across the board for the program, for the bar, for the lawyers, for the sponsors. We think this is going to be a win-win for everyone. It's just going to be bumpy until we get there. That's really all that I have in these slides. Are there, I'm happy to hang around and answer questions. I don't want to take too much of your guys' time today, but we are, I'm here. We're answering these questions all day, every day. Hopefully, as soon as we get something in the portal available for everyone, we'll notify you and notify the sponsors when the sponsor portal is up. But are there any questions that I haven't answered? At least I clicked on the queue. Now, I don't think there's been any new ones since earlier, but is there? Oh, actually, there's something I want to talk about because I think it affects you guys more than most in Charlotte. We got some emails about the changes that South Carolina has done to their CLE rules. It used to be South Carolina's rule was if you were compliant with the North Carolina rules, then that was all you needed to show South Carolina, and you didn't have any requirements, extra ones there in South Carolina. Well, they announced earlier this year, didn't give us a heads up on it, which is a little frustrating because we had been talking to them. They knew, about these rules, that they were no longer going to be able to honor the North Carolina compliance because we've moved to a 2-year reporting period, and that lawyers have to report 12 hours a year in South Carolina. We're going to continue to try to have a conversation and see if there's some solution or middle ground that we can make to make this easier for the dual licensees. But right now, there is nothing on our end that we're doing or can do to affect what South Carolina's decision is. So you need to make sure that if you're a dual licensee, that you understand your requirements in South Carolina and stay in compliance there. I hope that we can continue this a discussion with them and find something that will help everyone out. But the CLE board here did not recommend us making any changes to our rules related to reacting to South Carolina's decision. So just keep that in mind. I know that is especially important in Mecklenburg for the lawyers who have the cross-border practice, and so it's something we are aware of and hope we can have a dialogue and figure something out. But as of right now, you have your South Carolina requirements that are now separate, unique, individual to South Carolina, and you can't rely on maybe what you did in the past, which was staying compliant in North Carolina to satisfy your South Carolina rules. So that's one specific thing that's more that for you guys. But if I'm around, if you have any other questions, I'll stick around here for a few minutes. Chat. Is there anything you guys want to talk about? It doesn't have to be CLE. Anything related to the state bar, I'm happy to talk about.
And Peter, I haven't seen anything more come in with Q&A and chat. I think you addressed that you were going to be sending me the PowerPoint slides, and I will send that to everybody who was on the information session today. And we will also be posting a link to your presentation on the bar website. And at least for me, thank you for addressing the South Carolina issue, because we have received feedback of that in the bar office. So thank you for saying, we can at least pass on that we're working towards a better resolution or working together again. So thanks for that footnote at the end.
Sure. I don't anticipate anything that will probably be in place by the end of this year. So I think, it'll be important for the dual licensees to know that, but hopefully we can figure something out to find a long-term solution. Yeah.
That sounds great. Everybody, please feel free to reach out to Peter with questions. If you want to reach out to myself or Michelle Lee, also in the CLE office, that is fine. If we don't readily know the answer, we know Peter and Deborah or are just a quick email away. So we want to make sure we're all learning together, and this really turns out to be good for sponsors, attorneys, the state bar. So Peter, thank you so much for taking your time. We greatly appreciate that.
Sure. I'm happy to do it. Hope to be back soon.